Obviously, we're keeping legal for last because, everyone has so much energy around this topic, and Ben has been to a few of our events before, so he knows how it goes. We are going to go through a few things in this session. First, we're going to start with a fireside chat, and then we'll have some time for Q&A with Ben. I know we asked you guys for some questions you had for this legal session yesterday, so we've shared them with Ben and typed them up to remind you all. So we'll have some time to do that, and you can also ask additional questions. So before we get started, I just wanted to introduce Ben. We worked with him in a variety of capacities over the past few years, but he is currently Associate General Counsel at S-Power, and he used to be an outside counsel for mainly corporate buyers going through this process at Gates. So he has, I think, a really unique insight, given that he's been on both sides of the equation, and can provide kind of, again, both of those viewpoints.
I'll just say hello. Nice to see all of you. Some of you I may have met. I've done a few of these in the past, though previously, like Ali said, I was at Gates, so I was on the buy side. Now I'm on the sell side, so I see things a little bit differently, but I try to be as unbiased as possible. So happy to answer questions.
Awesome, thanks. So I've written up a few kind of questions based on themes that have come out for the next few days. So if you do have questions, I would ask that you just put them in chat. We're gonna have a time later for you guys to ask questions, but I just wanted to set up a few things that we've heard. So first off, I wanted to keep it pretty broad, but when you're serving for outside counsel for buyers running RFPs, what is either like the first thing you would tell them from a legal perspective, or the most important thing that they need to know from a legal perspective in writing these RFPs?
Sure. Yeah, so, generally outside counsel, we don't, or at least I didn't get involved all that often in sort of the crafting of the RFP. But what I will say is that I think it's important to have, and it's important for your legal folks as well as the business side to understand upfront, what it is that you really want and what your needs are. And I don't necessarily mean legal contract structure there, but what is it that you're trying to procure? What are your goals? Is it sustainability? Is it physical energy procurement? The reason I say that, and I appreciate it a lot more now that I'm with a developer, is, developers have all sorts of creative ways of thinking about energy procurement. And it's fine for a buyer to not know sort of what contract. In fact, sometimes it's better to not be wedded to a specific legal contract structure, but you need to have a sense up front of what it is that you want. Right now, VPPAs are sort of the rage. They're great for a number of applications. They're not so great for others, right? Do you want an energy hedge? Are you really just looking for RECs? Do you need physical energy? Do you need on-site versus off-site? It's sort of those types of things that you really want to have a concrete picture in your mind of what you need. And I think leading with that in an RFP is extremely helpful.
Awesome, thanks. And I think kind of related, are there any terms or conditions that are most critical or necessary for buyers to include in an RFP? Not necessarily like terms surrounding the RFP language, but things that you want to put in the RFP up front so that you understand what developers' points of views are in those terms coming later down the line.
Yeah, I mean, sort of piggybacking on what I was just saying, like product is a great one, right? Again, to the best of your knowledge, and I recognize that changes, right? You have corporates, and it's the same with cities. Some are more advanced in this, and you sort of know exactly what you want, and some are you're just getting into it and you're trying to figure it out, right? I mean, that's okay, but just trying to have a sense of what the product is that you want. Having that sort of upfront is very helpful. Another one that I think sometimes gets lost but is helpful is credit. and credit requirements. If you need, and again, this sort of depends on contract structure, but if you're going to want a developer to be posting credit support, which frankly you should, sort of put that up front. I never fully appreciated while I was outside counsel how much credit support and credit requirements, can impact the developer's model when they're trying to figure out pricing for you. So getting that up front is critical.
And can you just expand a little bit on that in terms of like how it impacts the modeling? Or like
Sure. Yeah. So, it's just at a basic level, right? If you're going to ask for a letter of credit versus a guarantee, there are carrying costs on those that can be quite significant. The amount of credit, are you comfortable with a step down? I mean, these are all things that a good developer may come back to you with and say, hey, what are you thinking on this? But the more sitting now on the other side and being in the room as these RFPs come in, we're often sitting there and thinking, okay, well, they're saying this, but what do they really want, right? And how much credit they want, and we literally have, development models, right? Giant Excel spreadsheets with all the inputs, and we're plugging everything in, and we're trying to get to a price. And so, the more you can think about those terms up front and put them into an RFP, the better. And often, the way that's done is you'll see sort of just sort of the bare bones of a conceptual term sheet, right? And the more you can populate that, the better. Again, recognizing that you don't need to have the set contract structure, right? It doesn't have to be a VPPA. It doesn't have to be on-site or off-site. Obviously, if you know, that's helpful. But sort of the more you can outline the framework of the product and the structure, the better.
Awesome, thank you. I know I've heard from some developers in some cities as well that for developers that are new to working with municipal customers, some issues may come up around the city's FOIA kind of, or the rights of people to FOIA the city documents. How have you advised cities, or what are your thoughts on, and from the developer side too, on like what you are able to provide in a contract that can be FOIA'd, or how you get around some of those requirements? Yeah,
actually, let me just say one more thing about terms, and then I'll switch to that, because something else that I'm reminded of now, PR and publicity terms, this is big for corporates. To the extent that you want to be making PR claims, you want naming rights, things like that. Most developers come from a utility background where it's power procurement, and they're not thinking about the sort of reputational side of contracts for a city or a corporate who's doing this more than just to procure power, right? There may be green goals, or you want to make certain statements. To the extent you have publicity asks, which are fine to have, try to get those up front too, because again, a lot of developers, and I saw this often on the buy side, is we would ask for things and they would say, oh, well, we're not in the business of putting up a billboard that says, this is the the city of Charlotte's renewable energy facility, right? And they'll get there on those things, but to the extent you can put that up front to get them comfortable as early as possible, it just avoids sort of a legal headache down the road. And you should be asking for those things too, by the way, because developers will give on them. So now turning to your other point about FOIA. Yeah, I mean, I think it's important just to make clear up front, right? And you can put that into the RFP if you have information that's going to be subject to, FOIA or other, open meetings. I mean, we being developers will get comfortable, like S-Power has gotten comfortable with that all the time. I just finished a PPA where it had to go to a public hearing with a board, and we knew it all along. And so, we were thinking early on about, okay, what do we need to designate as confidential? What can we not have out there? And usually that's just price. Most other stuff you can get comfortable with. But, I don't think that's an unusual thing at this point. I asked around a little bit. I'm not the attorney at S-Power who deals with FOIA and confidentiality, but I asked them this morning, have you dealt with this? And they said, yeah, it comes up all the time. We'll get comfortable. So again, I don't think you need to do that much legally up front, other than make it clear in the RFP that this could be subject to, FOIA or other things, and then we as a developer will craft a response in a way that we're thinking about that.
Thanks. So I think a few things have come up over the past few days, what kind of internal legal counsel does versus external legal counsel. And you mentioned it earlier about like, and so I'm interested in one, how have you forged the kind of the most successful or fruitful relationships with internal counsel at with customers that you work with? And two, like, where does that happen in the process? Where do you, I think external counsel is obviously pretty expensive in most cases. Yeah. Where do you find they have the most value?
Sure. Yeah, I mean, it sort of depends. I hate to give a lawyer's answer and say it depends, but it does sort of depend on your sophistication, right? On the corporate side, you have corporates that sort of the big players, the Googles, the Amazons, the Microsofts of the world, who have an energy team, right? And at this point, they have people, they know exactly what they want. They know what the products are. They know how to put together a term sheet. They may even have inside counsel who focuses on energy. And so they sort of can take that, most of the way in the RFP, and then maybe they pull in outside counsel as you get into like sort of final term sheet negotiations, and then of course into a PPA. If you're less sophisticated and this is your first go, and it was the same with, you have a lot of corporates who's so literally you get the call from some attorney who does something totally different and says, hey, I got the direction from management, we got to enter into a PPA. What is a PPA, right? And in that instance, if you don't have a consultant working for you, and often people do get a consultant to help with this, I think it does make sense to have outside counsel involved earlier. Don't be afraid of negotiating for flat fees or other fixed fees for various parts of the process if you do feel like you need help. I mean, I can tell you, while I was outside counsel, we always would negotiate these deals all the way through PPA signing under sort of a capped fee arrangement. So you can always sort of have certainty about what your costs are. Most lawyers and firms will agree to that. I have no, in fact, now I'm on the other side and I ask for it as well, right? Because developers use outside counsel too. But don't be afraid. You shouldn't just be deterred by cost, right? But I do think that most of the time, the value for outside counsel, unless you really need help at the very beginning, comes in after you've issued the RFP and now you've got proposals back and you're evaluating them and you're getting close to signing a term sheet. I think at that point, it makes sense to pull in outside counsel. It is helpful for outside counsel. It was always helpful for me to see the term sheet and make sure that I was comfortable with it, before you signed it, as opposed to having a signed term sheet and say, okay, now turn this into a PPA. And I might find, 3 or 4 things that are, minor, but will now be more of a headache because we didn't clean them up at the term sheet phase. So it's a long way of saying, I think, term sheet negotiation is probably when you want to have someone in there, unless you need them earlier, which then, that's your preference.
Great. I have one question left. I just wanted to prompt you guys. If you have any questions that are follow-ups to something that I just asked or Ben just said, feel free to put them in the chat now. If they're new questions, then I ask you to hold them to the Q&A session, but want to make sure that any threads are pulled. So you can write them in the chat if there are while I ask this last one. I think I'm interested in, now that you've kind of been on both sides of the process, what makes either like a really effective RFP or something that's really kind of helpful for the city and interesting for the developer to respond to, or on the opposite side, if you want to answer it this way, what makes a really terrible RFP? What makes the developer say, like, don't want to put my hands on that? Yeah, from that perspective.
Yeah, I mean, I went back and looked through, like, I now have the benefit of seeing these RFPs as they come in. And I went back and looked through a number of them to try to see, all right, which were the easiest to deal with. And again, I mean, I think they don't have to be long, right? But I think having a, sort of going back to my central theme, is like having a clear understanding of sort of what product you're after, or even what problem you're trying to solve, and having that up front is very helpful. And then, if you have some structure or concept around sort of a bare bones term sheet, that's also great. Because most developers, I would say, at least developers who are going to own and operate the project, look at this as a strategic partnership, right? And it's not just building the project. I mean, there are some who build and then they look to sort of pass it off to someone else. That's fine. That's one way to do it. But if it's someone who owns and operates, which S-Power does, we look at it like a strategic partnership, right? And so we want to help you solve whatever the problem is. Not just most developers want to help you solve whatever the problem is. And so, again, the more specificity around that is helpful. I also think it's sort of what not to do. If you have flexibility around timeline, around product, make that clear. I think the ones that and I can just speak for Aspire on this, but the ones that we struggle with the most are when it is an extremely rigid time frame. It doesn't seem like there's any movement on anything. COD is a big one, right? Are you flexible about COD? Does it have to be May 1st, 2020, or can it be December, right? What are your goals, right? And if there's some flexibility there, that's always great, because if they're very rigid, oftentimes it's just very hard, right? We're juggling a number of different things, and if it's a very rigid time frame with very, very specific terms, if you really need that, that's fine. But if you don't, you may scare people away who may not have that specific product with that specific time lane, but may actually be able to get you where you want to go. So I think just thinking about all that up front and being open to structure and various structures, if you can be, is very helpful.
Okay. I'm now going to move into the Q&A session. We have about 20 minutes left. These were some of the questions that came up yesterday. If you guys want to use our favorite feature, the annotate stamp feature, and just vote on the right side of your screen for any of these questions, or again, type in other questions, go ahead and I will kind of try to go through them based on energy and based on in the chat.
Okay. To start off, it looks like we have a question in the chat box regarding the legality of VPPAs and whether it's legal for cities to sign virtual PPAs. Can you expand on that a little bit?
The reason I ask is that it was just mentioned by one of the developers yesterday, and that gave me a gulp moment, because that's what I've been operating under the assumption that that's my best path forward. And if it's under legal standing, then I sort of would like to know, and under what circumstances and maybe where.
Yeah, I'm not sure exactly whether it's the legal standing of it from like an accounting standpoint. There are questions about, whether they're considered speculative contracts, whether the CFTC could at some point take a view of them. There's some question about that. I'm a few months removed from being in the weeds on that, because that was more of an issue when I was on the buy side, but I still think, so there hasn't been guidance on that. I do know that a big issue, and I'll try to get a little more information. By the way, this is for everyone. If you have a question here that I can't answer, I'll try to find out more for you and get back to you. But I do know that for cities, one of the big issues with VPPAs is whether you can enter into speculative contracts that aren't pure energy procurement. And that is really a specific state and sometimes municipal specific legal question that you should be talking to whoever your local counsel or in-house counsel is who handles procurement. That really differs state by state. I don't know the answers to those, but it is something to be thinking about. I'd be curious, I don't know who the developer was, I'd be curious to know exactly what they were talking about, because I still see VPPAs getting entered into all the time. So I suspect that it has to do with, if you're concerned about entering into a particular type of contract, whether or not if there's uncertainty about whether a VPPA falls into that or not.
Okay, thank you.
Sure.
Note on that, Carol, just letting you know, we have a few folks on our team across the CRA team that are looking into this in a couple states. So we might have a little bit more. I don't think we have a clear answer, but I think in the coming months, we hope to have some kind of more memos or talking points or visibility into the key issues are. So we'll share them once we have.
Yeah, there's a legal concept called Dillons Rule, which applies. Yeah. So
Real familiar with that.
exactly, which is, for those, if you're not, it's a general idea is that like a municipality is only able to do what it is authorized to do, right, under the plain language of whatever the enabling statutes are.
Mm-hmm.
I am not I'm not well versed in the nuances of like local and municipal law, and it changes state by state, but that's the general concern I often see around VPPAs. Sure. One I just saw real quick, and I don't know, Allie, if this is best for you, attorney with no familiarity of solar procurement, what resources, are you guys providing any resources on procurement? Because I know there's been a lot written on that in terms of thinking about different contract structures and.
Yeah, that's a good question. If someone from my team has thoughts on resources immediately, on our website, we do have a kind of resource bank where you can filter by type of contract or by type of resource. And it's internal resources we've created, but also links to a lot of external resources that we've reviewed and think are helpful. So I would say start there, cityrenewables.org, and we can get back to you. I think that was from Susanna, on specific legal ones as well. I don't know any off the top of my head, but I'm sure they do exist.
One that just pops into my mind that I've looked at before is the RMI, it's for corporates, but I think it's applicable, is the Corporate Purchaser's Guide to Risk Mitigation, which is out there. Not to, just plugging your own material, but that's a good one. And it gives you, thinking about a couple different structures. So that may be a good place to start.
Yeah, and for the folks in the offsite cohort, that's what we presented on in our second webinar, the Risk Mitigation Guide with Ratchet, who's one of the writers of that report. So you guys have all have access to that in the cohort folder.
I've read that thing many times. So
I think if that question was from someone in the on-site side of things, it might be for an attorney that's working more with a city or county on an on-site project. I think just getting caught up to speed on like what the process is like to put together the RFP would be helpful, to check out the procurement guidance that we have on our website that just kind of lays out what we've been doing in the cohort and maybe gets you caught up to speed on different aspects of on-site solar. So that'd be one thing.
Yeah, I would just echo Ryan's point there that the procurement guidance on our website is a very easy way to see the different types of solar renewables procurement very clearly laid out. So if someone truly has no familiarity with it, I would say that's a great place to start.
Hey, yeah, I just wanted to make a quick comment about the FOIA request. Just because I've been spending a lot of time on this recently, and I just wanted to reiterate that it's really important. We put it in our RFP for our offsite. However, the developer must have not seen that they had to be really clear in their proposal what parts of it were trade secret. And so just, I would say, talking about that during your pre-RFP meeting is really essential, so they can know for sure that they need to do that.
One thing I wanted to bring up is, as part of your RFP, I recommend including at the end like some sort of form statement that an officer of the respondent, so the developer, certifies to the accuracy of the RFP. Sometimes RFPs require sign off like that. Sometimes they don't. From an in-house legal standpoint, I always want to see that because it means that I have to review it and we have to sign off on it. And you would be surprised, or perhaps not surprised, how often, if that's not on there, these things go out without anyone from the legal team looking at them. And it's just not an issue, candidly, that originators within a developer are really focused on. Or, I mean, sometimes they are, sometimes they're not. You know, they're out there trying to make a sale. And so just by including that officers, I can tell you within S-Power, if you include a requirement that an officer certifies, that RFP response cannot go out without me looking at it. And then I have to take it up to our general counsel and he signs off. So to that point about making sure that, you know, the requirements are clear, if you include a clear sign off that says, you know, and I have certified to, you know, the FOIA requirements and all that, paraphrasing here a little bit, you have a better chance of making sure that you're getting something back that, you know, is clear and concise. And then also you can sort of point to that if there's a dispute down the road. So it's just something I recommend.
Thanks. I'm going to go just in order of what they were written down. So how do you make your timeline flexible?
Sure.
Yeah.
Yeah, I mean, one thing you can do is you can ask for pricing for various CODs. I see that a lot. So and you know, if you didn't, it's not the end of the world, right? You'll still get good responses. But, and you can also anticipate that may be a question that people come back with. But we'll often see something that says, all right, you know, please give us pricing for a December 2021 COD and give us pricing for a May 2022 COD. And what that does is it allows the developer to go back and look at sort of what assets they have in the pipeline and figure out what they can bid certain things at. And so that's a way of doing it sort of strategically without saying, hey, I'm open-ended, you know, I'll take whatever COD you can give me, right? You're sort of contemplating slightly different products and you're asking for pricing for one and then for the other. So you're giving the developer some flexibility, but you're also not making it seem like, you know, you have no requirements at all. So that's one way, I think, a good way to do it, at least on timing, which usually, frankly, is the biggest sticking point.
Great. And then there seems to be a lot of hearts, stars, and check marks around number 2.
Yeah.
What are common end of term options for purchasing versus extending agreements for both on or off site?
Yeah. So for on-site, you know, an option to buy at the end is fairly common. And those can be negotiated into a PPA. I've seen those very often, right? Because while it's on-site, it's typically on city or whoever's property. And so those are fairly standard in on-site contracts. At the end of the term, the buyer has an option to purchase the facility for whatever the fair market value or whatever agreed upon price you want to have, or otherwise the developer has to remove it. For off-site, you don't generally see options to purchase at the end. There are a number of reasons around that. One is regulatory. You know, generally you, at least as a city, or certainly most corporates, are not in the business of owning wholesale generation facilities. So there's, not to get too legal, but there are regulatory distinctions between a facility that's on-site, that sits on-site, and one that's actually selling into the wholesale market when you get into FERC implications, and that's the, Federal Energy Regulatory Commission. So generally you don't see an option to purchase off-site. You can, it's not all that common, but you can certainly negotiate for options to extend. I've seen them, and you can either do it as extending at a fixed price, or sometimes you can extend and you say that whatever the price will be for the extension sort of tracks off of an index or whatever. If you're in a regional transmission organization, so if you're in like the PJM region, you could have a extension at the end which tracks off of whatever the market prices are in PJM at the time. I can tell you that from a development standpoint, we're never looking at a project just based on the PPA term. So often a PPA term is 12 to 20 years. These facilities, new build, have useful life of 30, 35 years. So when we're modeling these things, we're always modeling them with a long, what we call the merchant tail. If it's within an organized market where we're looking and saying, okay, well, we're going to sell to, the city of Arlington in Virginia for 15 years, and then the next 15 we're going to sell into the PJM market. So that sort of pricing at an index is much more common if you're in a wholesale market. If you're not, then I think just a more conventional extension at a set price makes more sense.
Thanks. And just to note, I know there are a lot of questions and more coming in. We have about a little less than 10 minutes left, so we will try to get to as many as possible. But as we said before, if there are things we need to follow up on, we can send them to Ben.
I like the last question. That's been taking up a lot of my time.
Okay, well, let me add one more above it in the chat, and then
sure, yeah.
From Jared, to the point on city transparency and being upfront. Oh, I think it's the same question. Have you tended to see form contracts attach the RFP as an exhibit right off the bat?
Yeah, I have. It sort of, again, depends on, so for utilities, that's extremely common, right? Most utility RFPs that we respond to include a form power purchase agreement that you have to mark up. So it's pretty common if you have a contract. That also sort of goes to when you want to engage legal. So I can tell you when I was at K&L Gates, if we were engaged early in the process, we had a form virtual power purchase agreement. Most of the deals I was doing were VPPAs. We had a form VPPA that we could provide that you could then take and send out. So you can certainly do it. You know, again, that sort of depends though on how set you are on contract structure, right? Utilities generally know it's a physical deal. We want, you know, sort of all requirements PPA. We want all the products that the project can produce for 15 years, and that's it, right? And so they have a set contract for that. So if you're sure that you want a certain thing, then yeah, it can't hurt to include the PPA. But if you're not sure, it's not necessary. I will also say that be wary of including it. I sometimes question the value because generally developers will not mark them up heavily because they're afraid to mark them up too heavily. And if they do that, they're not going to get selected. So we will always take a very light pen. Like if I see something I don't like, usually I say something like, discuss this provision, right? So you're not going to get a lot back from me in terms of what my issues are, but I'm sort of reserving comment. So because the concern is always, well, if I don't say anything, then you're going to come back later and say, well, you had this and you didn't say anything, so we're not negotiating. So, you know, sometimes it's sort of limited value to get comments back on a PPA, but if you have one and you feel strongly about it and you know that you're going to use it, it certainly can help to get it out there and get the developer thinking about it.
Thanks. I'm going to go next to the blue one that was typed in the bottom and then go back to the voting dots. For the person who said the on-site lease applications of production problems or too little kilowatt hours, do you want to just expand a little bit on that question? I think, is it related to number 4, the energy usage reduced significantly?
Yeah, in Florida, you can't do PPAs. So the only option available really is a lease. Here we're looking at using a lease model to get to the benefits of an on-site PPA. So you can't put in production requirements the same way you typically would in PPAs in other states. So it's kind of fine line here, and we'll probably need to parse this out more later, but we're trying to find the sweet spot where we can require certain level of uptime, efficiency, and production without making it look like we're buying the power, as is disallowed by Florida statute.
Yeah, I'll be honest. I have not done much work in Florida. Like S-Power doesn't operate in Florida at all, and on the buy side, I was almost never involved in anything in Florida for sort of the reasons that you lay out. So I don't have the answer to that. That I think I mean, it's definitely an issue, but I think you have to get Florida specific counsel for that. That's just outside of what I've worked on.
I guess I'm not sure exactly what the question is.
So
I guess,
think
sorry.
No, I think the concern is if you're basically just leasing the land and then you have the power on it, like correct me if I'm getting this wrong, but if you're leasing the land and you have the power, it's almost like incidental to the lease that you're producing power there. How do you require that the power production is up to a certain amount, right? Like most PPAs on site have a minimum threshold where, hey, you have to produce a certain amount of kilowatt hours or megawatt hours a year. If you don't, you owe us damages, right? And so how do you do that in a lease where you're really not allowed to be purchasing the power, so you can't make it look like a power purchase agreement? So I think that's the nuance.
Yeah, yeah, the only distinction I would make is in this case, not lease land or roof space, but just to lease the equipment from a third-party vendor and therefore indirectly capture the ITC. We do have other projects where we have leased out the land to developers and they own the equipment, they just pay for use of the land. But in this case, we're looking to lease the equipment and benefit from the power production, but not actually buy the power, because you can't buy the power from anyone but a utility in Florida.
The only thing I would say is basically that that's one thing our legal hasn't flagged yet. I think a production guarantee wasn't an issue, but one thing that was an issue is going to be an issue for us is, the developers that we've talked to really want to do a 7-year, obviously, and then have an option for us to buy it after 7 years. But our attorneys feel that looks too much like a purchase instead of a lease. And so they're not comfortable with that. So we have to make our term a 20-year term. And so I was hoping the production guarantee was going to be okay language, but we'll let you know how that goes.
I mean, we had, I guess, assumed all along that a production guarantee was going to be, I guess, kind of a prerequisite for entering into a solar lease, and so that there's some, I'm trying to think of the word I want to use here, but some assurance that the business case will hold. We haven't really started the negotiation process with any of the developers, so this probably would have been a question that we should have asked in the previous session in hindsight, right? But we haven't really discussed it at length. I think we've just kind of operated all along that this would be part of it.
The developers have said that they would give us a production guarantee, but I don't know how that would play out in the contract.
I'm going to pause that conversation here because we're running up to time and I want to answer the last question. I will follow up with you guys. We can kind of continue discussing this or figure out next steps.
Yeah, and let me know. I may be able to get some more information on that too.
Thanks, Ben.
I can also quickly answer 4 if it's helpful, because I know that sort of.
Sure. Yeah. If you want to do 4 and then 5,
sure,
as concisely as possible. We have like 2 minutes left.
Got it. Real quick on 4. You can ask for it. It's hard to do. One thing I would urge you is always to be thinking about is financing. So for big projects, developers are always financing the projects. Financing parties want a fixed and certain revenue stream. So if what you're really asking for is at some point in the life of this contract to be able to go in and say, hey, we no longer need 50 megawatts, we only need 40. You may be able to negotiate for something like that, but there's going to have to be some sort of downsizing payment or something like that. I think it's going to be very hard for a developer and financing parties to get comfortable with sort of a right at some point, at a buyer's option to just downsize the whole revenue stream. If you need something like that, I would bring it up front and really discuss it, because that's sort of a tricky one. And then on the last one, I've been dealing with this now. This is the #1 issue for us and for everyone, trying to figure out how to account for the uncertainty surrounding COVID-19 in our contracts. I just finished a PPA last week where, COD is a few years out, and, we're sitting here saying, well, we don't really anticipate any delays now, but, it's just impossible to know. what I can say from the developer side is just start the conversation. Like, we're all thinking about this. We're all worried about this. And, just try to be as open as possible about what the concerns are. I think we're all sort of facing the same risks here, right? Like, if there's an issue with permitting because the government agencies aren't open, right? It affects the state as much as it affects us. Thinking about COVID and making sure that depending on what you want, whether or not it's included in the definition of force majeure, which of course is an important part of the contract, usually doesn't come up early in the RFP, but I suspect that now you'll start to see it more because people are going to be concerned about that. We just responded to an RFP a few days ago, and I made sure to put in there like, hey, we need extra delays or free delay days and the ability to push out COD if, in 6 months, everything is still shut down, right? Because we just have no control. You have no control. So I think one way to do it in the RFP is to just ask a question, ask the developer to respond to how they are managing COVID-19. What have they heard from their suppliers? Because that's often what's going on, is that we sort of sit in the middle and, we need to procure solar panels and we're sort of at the mercy of our suppliers as well. So start that conversation. Don't be afraid to ask questions about it. I think that's what I would do up front. And then in terms of risk mitigation, as you're contracting, just be very clear in the language. One thing that we've proposed a few times is additional delays and the ability to push out COD for a force majeure event solely related to COVID. Because I can tell you that the other thing that developers will do is if a project is delayed already, they'll say, oh, we're already delayed and now we've got the coronavirus. So let's just point to that, right? And so don't be afraid to ask a lot of questions. I'm, not saying anyone has malintent, but it's fair to scrutinize it. But I think everybody needs a little bit of flexibility right now because I can tell you that it's just unlike anything we've seen before and everyone's sort of scrambling. So sorry, that was sort of a lengthy answer, but
That's okay.
this is very pertinent.
Yeah. Awesome. Well, thank you so much, Ben.
Sure.
That is the end of our legal session.